Welcome to the Supreme Court of the United Kingdom, where today we are beginning the hearing of an appeal in the case of Poof and the Commissioners for Her Majesty's Revenue and Customs. This is a tax appeal concerned with what are known as discovery assessment to income tax. I'm hearing this appeal with four colleagues whom I'll introduce now. First, Lord Briggs. Secondly, Lord Sales.
Good morning.
Lord Leggett.
Good morning.
And Lord Burrows.
Good morning.
The Revenue are represented by Miss McCarthy, Queen's Counsel, and I'll hand over to her now to begin her submission.
Thank you very much, my lord. I appear with my learned friend, Mr. Brinsmead Stockham, on behalf of the Appellant HMRC, and Mr. Ghosh and QC and Mr. Bradley appear on behalf of the Respondent, Mr. Tooth. With your lordship's permission, I'm going to take our written case as read, and I adopt the submissions we make in it. In my oral submissions, I intend to deal with the discovery issue first, before turning to deliberate inaccuracy. I will develop what we've said in our written case on deliberate inaccuracy in my opening, but since that's ultimately a response point for HMRC, I've set aside a little more time than usual for my reply to address my oral submissions on that issue.
Perhaps before you begin, I should explain that we appreciate that Mr. Ghosh has made a number of points in his written case as to the extent to which your submissions fall within the scope of your ground of appeal. We think it's best that we hear what you have to say and Mr. Ghosh in reply, and we can deal afterwards with any issues arising from departures from your ground of appeal.
Certainly. My lord, just to make sure I've properly understood, what your lordship is suggesting is dealing afterwards in the sense of after this hearing, rather than me addressing pleading points up front.
That's right. Effectively, we think it's best to hear what you have to say, de bene esse, and if we're persuaded that you really are going beyond the scope of your ground of appeal, then we can deal with that when we come to our decision.
I'm grateful. Thank you, my lord. That's a very helpful indication. So starting off then with the discovery issue, just to set out the order of my submissions, I'll begin with the legislation before moving on to three cases which we say properly articulate the requirement for the assessing officer to have made a discovery. I'll then look briefly at the two main cases which have given rise to this concept of staleness, Charlton and Patullo, and I'll make my submissions on why we say they're misconceived. Then I'll draw the threads together on the law before turning to the application of those principles to this case. And at this point, I intend to take your lordship to the decisions below so far as we say they're relevant, and also to address my learned friend's points on pleadings and the evidence. Finally, on the discovery issue, I'll make brief submissions as to why, if the court concludes that a concept of staleness does exist, contrary to what we say is the correct interpretation, it shouldn't invalidate the assessment here anyway. I hope to have finished my submissions on discovery shortly after the short adjournment, and then I'll move on to the next issue. So starting off with the legislation, if I may please, my lord, please could I ask you to go to PDF page 860, which is section 29, assessment where a loss of tax is discovered. And we can see from 29.1 that the relevant condition is if an officer of the board or the board discover, and moving on to B, that an assessment to tax is or has become insufficient, moving on to the tell piece, the officer, or as the case may be the board, may, subject to subsections 2 and 3 below, make an assessment in the amount or the further amount which ought in his or their opinion to be charged in order to make good to the Crown the loss of tax. We say that this condition is satisfied where the assessing officer reaches a genuine and reasonable conclusion that a self-assessment is insufficient. Now, if that is the correct test, it's satisfied here, At no point has either the respondent or the courts or tribunals below said otherwise as regards the assessing officer's state of mind. We say that properly analysed, the focus is solely on the assessing officer, and what anyone else in HMRC may have believed or may have realised before him is not relevant. Now, as I'll go on to show, introducing a concept of staleness has led the courts and tribunals below to contort what we say is the natural and correct meaning of these words. Just moving through the rest of section 29, section 29.2 isn't relevant here. 29.3 precludes an assessment unless one of two conditions has been met. Over to the top of the next page, section 29.4, the first condition, that's the condition that HMRC relies on here. Section 29.5, the second condition, that's a freestanding condition that's concerned with the quality of a taxpayer's disclosure. And critically, it does not save a taxpayer from a discovery assessment if the first condition at 29.4 is met, i.e. in the case of careless or deliberate conduct. Subsection 6 and 7 supplement 29.5, so aren't relevant here. And then just scrolling down to the top of page 862, please, you'll see subsection 29.8. That gives the tribunal on a statutory appeal exclusive jurisdiction over the question whether the two conditions, so that's the conditions at 29.4 and 5 are met, but only in respect of that. If I could please ask your lordships to turn to PDF 864. This is section 34 of the Taxes Management Act, the ordinary time limit of 4 years. And I'll show you the wording of section 34.1. Subject to the following provisions of this act, ... an assessment may be made at any time, not more than 4 years after the end of the year of assessment to which it relates. So section 34.1 expressly permits HMRC to assess at any time, subject to what's identified in the first sentence, the following provisions, i.e. later provisions of TMA, or provisions of other acts allowing a longer period. Now, we say that it's clear that the express words of section 34 extinguish the possibility of implying a shorter time limit for assessment into either the word if or the word discover in the provision that appears earlier in the Act, such as section 29.1. And any other interpretation, we say, undermines legal certainty and is entirely contrary to the most fundamental principles of statutory construction. It also results in capricious outcomes, which I'll demonstrate in due course. And I will also show your lordship why it is we say that the cases on staleness have taken a wrong turn when they suggest that the House of Lords judgment in Senland gives rise to such an interpretation. Just for your note, you'll see section 34.2 gives the tribunal in a statutory appeal exclusive jurisdiction over the question of whether the time limit has expired, but that, we say, is plainly a reference to the statutory time limits, not some other imagined reasonable period. Now, the longer time limit is on PDF 866. This is the longer time limit that HMRC has to rely on in this case. Section 36, loss of tax brought about carelessly or deliberately, etc. And the relevant subsection here is section 36, 1 big A, an assessment in the case of various situations, which you can see include at little a, deliberate conduct. Then at the end, may be made at any time, not more than 20 years after the end of the relevant tax year. So section 36 is not subject to any other provisions of the TMA, and the clear wording at any time appears again, and we say make it impermissible to read into section 29, a requirement which has the effect of prohibiting assessment during this 20-year window. Now, by way of comparison, we've identified in our written case 2 examples of time limit provisions which have been framed differently. My Lord, I think you should have been provided with, I hope, a short supplementary PDF bundle, which is 11 pages. Thank you, I'm grateful. So the first provision is on supplementary PDF page 10, please. That's section 43, the time limit for making claims. Now, I should say we refer erroneously to section 42.1 in our written case at paragraph 48. That should, our written case paragraph 48, be a reference to section 43. Section 43 is the time limit in which taxpayers can make claims, and that says subject to any provision of the Taxes Acts, providing a longer or shorter period, taxpayers may make claims for relief within 4 years. So here, this drafting makes it possible for the legislation to provide for a shorter time frame. But even then, the legislation is concerned at provisions which expressly identify shorter periods. Now, it's right to say that there's no concept of discover in the taxpayer claim legislation. However, the word if appears. If a taxpayer makes a loss, then the taxpayer may make a claim. And so one example of that is the provisions with which we're concerned here, section 128 of the Income Tax Act 2007. And it would be quite wrong to say, well, actually, taxpayers must act within a reasonable period. Let's make up what that reasonable period would be, because that would obviously undermine legal certainty. And it would prejudice taxpayers if, in fact, there was some vague, unspecified, shorter, reasonable time requirement. So that's moving back to the main PDF, if I may. The second example, we identify at paragraph 55 of our written case, and that's the comparison with the VAT regime. The relevant legislation is on PDF page 900 of the main bundle, please. And VAT assessments are split out, the legislation is split out in 2 parts. So 77, section 77, which is at PDF page 900, that contains various long stop time limits. And then the second piece to the VAT assessment regime is at PDF page 897, and that's section 73. And the relevant provision that I'd like to show your lordship, please, is at the bottom of page 897. It's 73 subsection 6. So in certain circumstances, VAT assessments must be made within the long stop time limits at section 77. And then we see this, and shall not be made after the later of the following, 2 years after the end of the prescribed accounting period, or 1 year after evidence of the fact sufficient in the opinion of the commissioners to justify the making of the assessment comes to their knowledge. So we say section 73(6)(b) is a provision that in effect requires HMRC to act promptly. But even there, Parliament has set out a clear window of a year and a clear test for determining when that period starts, which focuses on, objectively, when it was that the revenue received the last piece of the puzzle necessary to justify the making of an assessment. Now, we say the VAT test is simple and straightforward. It doesn't require asking every individual that preceded the assessing officer what they thought and when they thought it. I don't require your lordship to go to it now, but just for your note, we've included at PDF page 1822 a recent decision of the upper tribunal in a case called Safe Store, just for illustration, as to how this test operates. The upper tribunal in that case addresses the obvious point that an officer's subjective opinion can be inferred from the documents and all the other evidence. So in that case, HMRC was able to prove that they were within time without actually having to call a live witness. And just for your note, the relevant paragraphs that will that deal with the limitation argument in SafeStore. It's paragraphs 62 to 72, and that starts at PDF 1842. Now, in contrast, the staleness test requires HMRC to prove that no officer who's ever looked at the file formed the view that the self-assessment was insufficient. Now, taking this case as an example, on the taxpayer's case, HMRC would have had to have called live evidence of a further 6 officers. If you look at how many people throughout the years signed off letters, there are 6 of them, in addition to the 3 that they did call. And that's before you take account of the fact that the letter writers might not have been the decision makers at the time. Because we see with the example here, Mr. Nigel Williams was the officer that reached the decision. He delegated the letter writing to a colleague, Mrs. Thorley. She in turn delegated that to another colleague, Mr. Anders. Now, again, just taking this case as an example, 4 of those 6 officers would have been giving evidence in 2016 before the first tier tribunal as to what they may or may not have thought about a particular taxpayer's tax return when they looked at a file some 5 years earlier. Most, if not all, because HMRC officers are shuffled around the department on a reasonably regular basis, would have moved on from their previous roles. Some of them might have left HMRC entirely. Realistically, none of them could be expected to have perfect first-hand recall as to what they might have thought of a taxpayer's affairs that they happened to look at some 5 years earlier. Now, as we'll see, the case law makes it clear that discovery is supposed to be a low hurdle. But in contrast, if my learned friend is right about what he says is the correct test and the evidence required to prove it, we say that it becomes unworkable in the real world. And it cannot be the case that Parliament should be taken to have intended to impose an impractical additional temporal hurdle in circumstances where the legislation, we say, expressly precludes any such test from being inferred. Now, the point that we make in our written case is that actually Section 29(1) was amended at around the time the VAT Act was enacted, and it's striking that Parliament did not choose to import the same test as that used in the VAT legislation in the TMA. My Lord, those were my submissions on the legislation. I next intend to move on to the 3 authorities which we say properly articulate what is meant by the requirement for the assessing officer to discover. So the first 2 cases, McKinley's trustees and Senlon, are also relevant because these cases supposedly form the basis of the staleness concept. But as I already mentioned, I'll demonstrate why we say they're wrong, or sorry, that those cases are right, but the later tribunals have wrongly inferred from them a principle that the court wasn't intending to set out. It's also relevant to note that those 2 cases predate self-assessment, and so they involve situations where the taxpayer submitted all the relevant information to HMRC. HMRC raised an initial assessment, and then sometime later, a second officer sought to raise a second assessment when they realised the first officer had got it wrong. So no new facts came to HMRC's attention in the meantime. At the time of these 2 cases, the legislation also didn't contain the equivalent of Section 29(5), so it was simply a 6-year time limit with additional times for carelessness and for, as the legislation was, for fraud. So the first case is McKinley's trustees, and that's PDF page 1080. Here, it was common ground that full disclosure was made by the trustees. Just briefly as to the chronology, one inspector raised an assessment which omitted certain income in November 1935. A second inspector took a different view and raised a further assessment 2 years later in December 1937. The trustees argued that there couldn't have been a relevant discovery because HMRC had all the facts before them when the first assessment was made. And for your note, my lord, the relevant facts are summarised in Viscount Simon's judgment. No, I'm sorry, that's wrong. In the Court of Sessions judgment, PDF 1084. The Court of Session ruled that the assessment here was valid, and they attributed a wide meaning to the word discover. If I could ask your lordship, please, to turn to 1085. Right at the bottom of 1085, this is as part of the Lord President, Lord Norman's decision. He says halfway through the last paragraph that the word discover in itself may be taken simply to mean find out. Over the page to the top of 1086, just above, or sorry, nearing the end of the first paragraph.
Well, perhaps it's important what he says immediately after that discover may be taken simply to mean find out. He says what has to be found or found out is that any properties or profits chargeable to tax have been omitted from the first assessment.
Yes.
Yeah. Okay.
Yes. So just near, and we say that's perfectly correct, but that doesn't answer the question whether or not HMRC have to assess it within some reasonable period of time thereafter. So over to the top of page 1086, and nearing the bottom of the first paragraph, he goes on to say they are apt, so these words are apt to cover the case of a discovery of a mistake in the assessment caused by a mistake in the construction of the partnership deed, or it may be caused by a mistake in the law applicable to such deed, even where there has been a complete disclosure of all relevant facts upon which the correct assessment might have been based. And he says this, I do not think it is stretching the word discovers to hold that it covers the finding out that an error in law has been committed in the first assessment when it's desired to correct that by an additional assessment. Moving on then to the next paragraph just below the heading of the law report heading, so on to internal page 313. He says this 4 lines down. Of course, if there are any reason in the context restricting the word discover to the discovery of an error of fact, that restriction would necessarily receive effect. But in my opinion, the context points not to any such restriction, but on the contrary, to so wide a meaning that the word ought to be held to cover just the kind of discovery that was made here. Moving on to Lord Fleming's speech at the bottom of page 1086. He says 3 lines down, it seems to me that when the special commissioners came to the conclusion that the original determination was wrong, they made a discovery. And then over the page, top of page 1087, the opinion of Lord Moncrieff, the last 3 lines of his opinion. From the facts stated in the case, it's abundantly clear that the special commissioners have made a 2-fold discovery. I should say that's a reference to the revenue. They have discovered the fact of an underassessment and, moreover, discovered the course which should be followed in putting the error right. So the main points we say that emanate from this case is discovery has a wide meaning. The revenue aren't precluded from raising a further assessment simply because they had the material all along and failed to act correctly. There's no hand-wringing over whether, when the correct position was found out, who found it out, precisely how they found it out, and why they didn't appreciate this from the outset. And we've seen what Lord Moncrieff has said at the end, discovering the course which should be followed to put the error right was itself a discovery. Now I'd like to move on, please, to 1088, PDF page 1088. And this is the House of Lords judgment in Senlin. Now, Senlin was another case where a previous inspector in possession of the full facts issued an assessment omitting a sum from trading receipts. A later inspector reached a different conclusion and issued a second assessment. The taxpayers here argued that there could only be a discovery if new facts came to light, and HMRC shouldn't be able to rely on their ignorance of the law, since it would be quite wrong, to use their words, to put the taxpayer in peril for 6 years, when the taxpayer had made the revenue aware of all the facts on day one. And that part of the taxpayer's argument can be found at the foot of PDF page 1094. Now, there are parallels with the taxpayer's argument here, in that they say, well, the revenue shouldn't be allowed to rely on their own failure to assess sooner. Albeit, of course, they identify a different reason for the failure. The relevant passage that I'd like to turn to, please, my lord, is PDF page 1100. And it's at the end of the paragraph that begins, I come to the second question. So here, Viscount Simons refers to the case of McKinley's trustees and says, I think that decision was clearly right, and I find the judgment of Lord President Normand wholly convincing. And then he says this, I can see no reason for saying that a discovery of an undercharge can arise only where a new fact has been discovered. The words are apt to include any case in which, for any reason, it newly appears that the taxpayer has been undercharged, and the context supports rather than detracts from this interpretation. So that is the sentence that's been, we say, taken out of context in the later cases. The words are apt to include any case in which, for any reason, it newly appears that the taxpayer has been undercharged. And I have 5 points to make about why we say that this concept of staleness was plainly not what Viscount Simons was intending here. First point to make is the sentence is inclusive. It says the words are apt to include, but later tribunals have interpreted this as being an exhaustive statement. And from the language, we say it's plain that it isn't. Secondly, the sentence is at the end of a paragraph where Viscount Simons concludes that a broad, expansive definition of discover is correct. So in its context, we say it would be perverse to give the sentence the effect of narrowing the meaning, in fact, of the word discover and creating some additional new requirement. Third, we say the phrase must be understood in the context of the case at hand. So the competing arguments in Senlin were whether a discovery could only encompass the discovery of new facts, or if taking a new position on the law would suffice. Against this, we say, well, newly deserves no special attention because that was simply the context of that case and the context of the competing arguments. And indeed, the sentence in this case would work perfectly well without it. The words are apt to include any case in which, for any reason, it appears that the taxpayer has been undercharged. Newly isn't supposed to be the focus of that sentence. Once the context of the case is appreciated, it's clear, we say, that Viscount Simons' focus is instead intended to be on the words for any reason. And yet no weight at all has been given to those words in the cases on staleness. Fifth and finally, we'd say that Senlin was not a case about administrative delay between discovery and assessment anyway. So Viscount Simons cannot sensibly be interpreted as imposing a new condition that HMRC must act promptly whilst the discovery is new or fresh. What happens, we say, after HMRC finds out is governed by the express time limits and nothing else. And if I may just ask you, please, to turn up, it's the quote that we set out at paragraph 42 of our written case from Morano, which is it's only a first-tier decision, but I think it puts the point very nicely. It's PDF 1858. And it's paragraph 79. And Judge Redstone in the first-tier tribunal says this: however, a discovery does not lose its character as a result of the passage of time. William Harvey discovered how the blood circulates, Alexander Fleming discovered penicillin, and Marie Curie discovered radium. Those discoveries are no longer new, but they're still correctly described as discoveries. And we think that that's a perfectly apt way of looking at what it means to discover. The third case that I'd like to show you, Lordship, in relation to what we say is the correct approach to discover, is Jerome Anderson, the Upper Tribunal's decision in Jerome Anderson. And that can be found at PDF 1597. And what we say, which this case illustrates, is the word discover is in fact intended simply to protect taxpayers from assessments based on mere suspicion or speculation, when the assessing officer in fact has no genuine or reasonable basis for his conclusion. So it's to stop fishing. In other words, we say it tests the quality of the assessing officer's awareness, and it sets a minimum threshold that he needs to satisfy. But once he has crossed that qualitative threshold, as Morano correctly identifies, that quality isn't subsequently lost simply because of the passage of time. And we address the case in paragraph 54(2) of our written case. So in Anderson, the facts are just very broadly that the taxpayer argued that at the time HMRC assessed, the officer didn't in fact have sufficient information to form a reasonable basis, and so the assessment was merely speculative and it should be struck down. Just one point to note, the Upper Tribunal in this case was Mr. Justice Morgan sitting with Judge Berner. As is noted in the Upper Tribunal's decision itself, Judge Berner was part of the Upper Tribunal, in fact, in Charlton. And that's interesting for a reason I'll come on to in due course. So if I could ask you Lordships, please to turn to page 1606, PDF 1606. Here, the Upper Tribunal is setting out the meaning of discover. And they say at the end of paragraph 11, it's not in dispute that the concept of a discovery by an officer involves the application of a subjective test as to the officer's state of mind and an objective test as to whether it's open to an officer to have that state of mind. Moving on, please, to the next page, 1607. The Upper Tribunal then goes through various of the older cases in the case law. At 1607, in a quote from ex parte Kensington Income Tax General Purposes Commissioners, the text highlighted in bold, so that's 1607 between little c and little d, if the surveyor discovers, mean if the surveyor comes to the conclusion from the examination he makes and from any information he may choose to receive. Mr. Justice Avery thought that the word discovers in this section means has reason to believe. Mr. Justice Lush took the word as equivalent to finds or satisfies himself. Moving on then, please, to 1068. At paragraph 20, having set out the case law, the Upper Tribunal says that the word discover in section 29(1) was in its view intended to have its established meaning by the time that section 29(1) was enacted, and we would agree with that. Going on then, please, to paragraph 23 on 1609. The Upper Tribunal then quotes from the Court of Appeal judgment in Sanderson. And I'd ask your lordships, please, just to look at the words in bold just by little e. The exercise of the Section 29(1) power is made by a real officer who's required to come to a conclusion about a possible insufficiency based on all the available information at the time when the discovery assessment is made. Sanderson, in that paragraph, talks about the distinction between the notion of a discovery and the taxpayer protection afforded by Section 29(5). So the case where the taxpayer has made sufficient disclosure in his or her return. At the bottom of page 1609, the Upper Tribunal draws together the threads from the authorities into a series of 11 propositions. And my lord, please could I invite you just to read the first 8 propositions to yourselves which concern Section 29(1). And so, my lord, the propositions there are all focused on the subjective and objective state of the assessing officer's mind. The subjective and objective elements are then broken down in separate discussions. So at the foot of 1610, PDF page 1610, paragraph 25 starts off with a subjective test. It's clear that before an officer makes a discovery assessment, he must have formed a certain state of mind. The question is, what must the officer think or believe? At paragraph 26, so over the page 1611, paragraph 26, the Upper Tribunal says any test which is devised as to the necessary subjective belief on the part of the officer must be a practical and workable test, and we would wholeheartedly agree with that. And then there's further discussion about the subjective test of the subjective state of mind of the assessing officer, the subjective element of that test. Please could I invite your lordship just to read paragraphs 26 through to 28. And so, as I noted, the focus of the inquiry is on the subjective officer, the assessing officer. The objective test is set out at paragraphs 29 and 30 at the bottom of what PDF page 1611 onto 1612. 29, the Upper Tribunal agrees that there's the need for the assessing officer to act honestly and reasonably. And then at 30, the upper tribunal says this: the officer's decision to make a discovery assessment is an administrative decision. We consider that the objective controls on the decision-making of the officer should be expressed by reference to public law concepts. Accordingly, as regards the requirement for the action to be reasonable, this should be expressed as a requirement that the officer's belief is one which a reasonable officer could form. It's not for the tribunal hearing an appeal in relation to a discovery assessment to form its own belief on the information available to the officer, and then to conclude, if it forms a different belief, that the officer's belief was not reasonable. Now, I read that out because, of course, it's relevant to what we say, how we say discovery should be tested. But just as a note, we say that this approach is the correct approach if it is the case that the Supreme Court is going to say there's a concept of staleness. Why it is we say that that should be tested against public law requirements that we've identified in our written case. So I'll just refer back to that in due course. And just as a matter of interest, please could I ask your lordship to go to page 1615. You'll note that at paragraphs 44 and 45, there is a discussion about staleness. And the reason for this discussion is counsel for the taxpayer said, well, of course, if you interpret the discovery threshold too low, then HMRC will cross that threshold so easily that realistically, by the time they assess, you could say in a lot of cases, the assessment is stale. So that was the taxpayers' counsel's justification for saying that actually the revenue needed to be more certain, to have a firmer conclusion than they did in that case before discovery was satisfied. And it's interesting to note that notwithstanding that Judge Berner was part of the upper tribunal in Charlton, the upper tribunal at this stage in paragraph 45 says, well, staleness isn't relevant on the fact. So in those circumstances, we prefer not to express any further view one way or another on that possibility. So pausing there, this is how we say section 29(1) applies. Discover poses a low hurdle. It must be a practical and workable test. The focus is on the assessing officer and his state of mind. The intention is to protect taxpayers from assessments based on mere suspicion or speculation. And that's achieved by asking whether the assessing officer honestly and reasonably believed that there was an insufficiency in a self-assessment. We see from the cases that at the time of assessing, the officer need not have come to any conclusion about the conditions at section 29(4), 29(5). It's also the case that the requirement for an officer to discover is different to the taxpayer protection at 29(5). Indeed, it's perfectly possible, we would say, for the assessing officer to have validly discovered something, even if HMRC was in full possession of all the relevant information throughout. And because the focus is, we say, correctly on the assessing officer, it makes no difference that someone else in HMRC might have realised something about the taxpayer's self-assessment before. That isn't relevant because the focus is on the assessing officer. And if I may just test 4 scenarios. I said earlier that if the concept of staleness exists, then it gives rise to capricious results. So just testing these 4 scenarios where an officer receives a return. Scenario 1, he puts it straight in a drawer. Scenario 2, he reads it, but not very carefully and doesn't spot anything wrong. Scenario 3, he reads it carefully, but makes a really fundamental error on the law and doesn't spot anything wrong. Scenario 4, the officer spots a mistake, but then happens to go on holiday, forgets all about it and doesn't do anything. Now, assume for the sake of argument that in each of these cases, the officer moves on, a new officer comes in, picks up the file 3 years later and immediately spots an insufficiency. and also assume for the sake of argument that a taxpayer hasn't received any communication at all from HMRC in the meantime. In each of these four scenarios, the taxpayer's experience has been identical throughout. They haven't received any communication from the revenue one way or another about their return. And the reason why no action was taken on day one, in my examples, is all down to administrative failure of some sort. Now, on my learned friend's view of discovery, there would be a valid discovery in the first three examples of administrative failure, but not in the fourth. And assuming for the moment that either of the conditions at 29.4 or 29.5 are satisfied, the revenue would be able to assess in the first three examples, but not in the fourth. And we say that that simple example, those four scenarios, just go to show why there is no principal basis for subjecting taxpayers to different outcomes. Now, depending on the taxpayer's conduct, a point in time will be reached whereby the loss of tax is simply put out of HMRC's reach, be it 4 years, 6 years, or 20 years. But that is governed by the express long stop time limits which Parliament has determined in the interest of finality and legal certainty, that HMRC can take no further action. But up until those time limits have been reached, there's no rational basis whatsoever, we would say, for treating taxpayers who have identical experiences differently, merely because in this one special case, there's been a particular reason for the administrative failure, as opposed to any other reason of administrative failure. Next, my Lord, I'd like to move on, please, to the two main upper tribunal decisions which introduce the concept of staleness. These are Charlton and Patillo. And I'm sorry. Yes, my Lord.
I wonder if just before you do, given four scenarios, do you go as far as saying there's an assessing officer who, on the very first reading of the tax return after it's arrived, says, more than suspiciously, but without certainty, that's wrong, is then making a discovery at that first stage?
And then we're talking, I'm sorry, my Lord.
Or does there have to be some prior stage at which it's either ignored or misunderstood? In other words, does the discovery, as is illustrated by the earlier cases, but that doesn't mean to say that they don't allow any wider perception, does it mean that the discovery has to reflect some change of perception on the part of the revenue from what their perception was when they first read the return?
And so, my Lord, we would say no, it doesn't. But on any view, there's a change in perception in the sense that, so taking it in stages, prior to self-assessment, it's the revenue who makes the original assessment in the first place. So as a matter of fact, someone in the revenue will have formed a view because they need to issue the original assessment. Necessarily, therefore, the second officer that comes along will have had to have taken a different view in order to come to the conclusion that the revenue's first go was wrong, and they're going to issue a second assessment.
But what if it's a self-assessment return?
Yes. Post self-assessment, we would say that on any view, there's a change of perception in the sense that before the revenue looks at the return, they have no view one way or another. The moment the officer picks up a return, they have discovered something by virtue of reading the return and finding out something about that return. And put it another way, the way the tax system operates now, which is touched upon in the decisions below in this case, it's process now, check later. So the return is read in inverted commas by a machine, and at some point a human may or may not look at it. You may therefore end up with a situation where the very first reading of the return happens to be after the inquiry window has closed. And if the very first officer, human reader of the return, picks up the return and spots an error, that officer necessarily has made a discovery it doesn't matter that officer didn't have a prior subjective view about something different.
Thank you.
And actually, in a sense, discovering penicillin and so on, all of those are discoveries where before the threshold was crossed, there might not have been a subjective view one way or another. So discovering America, it may not have been the case that someone had thought, well, America's not there, although, of course, at some point it would have been. But the discovery is simply crossing a threshold from a state of not knowing to a state of knowing, as opposed to believing the opposite to a state of knowing. So moving on then to the two main upper tribunal decisions, Charlton and Patillo. Just for your lordship's note, these cases are bookended by the earlier case of Corbally-Staunton, which, just for your note, is PDF page 1240 at 44, where the upper tribunal floats the proposition that such a concept might exist in a single paragraph. And Beagles is the case that's currently stayed before the Court of Appeal, if you like, at the end of the line. Again, just for your lordship's note, that's PDF page 1647 at 59. And there, interestingly, actually, the upper tribunal holds that it can see the arguments in Patillo both ways, but since they don't feel able to conclude that they are convinced Patillo is wrong, they don't overturn it because they consider the matter is more appropriate to be considered by the higher courts. I don't intend to go to those cases. Now, as I've already noted, we say that those cases turn on a misunderstanding of Senlin, and there are many authorities which warn about the dangers of displacing the words of a statute with glosses that appear in the case law. At paragraph 45 of our written case, we've given the example of the Supreme Court's judgment in Rangers, where at paragraph 11, and so for your lordship's note, that's PDF 1444, Lord Hodge warns against focusing on judicial glosses, which might be helpful in the circumstances of the cases in which they were used, but don't replace the statutory words. Charlton can be found PDF page 1306. In Charlton, the taxpayers entered into an avoidance scheme and disclosed DOTAS numbers in their returns. The revenue, through administrative oversight, essentially failed to open the inquiry in time. But once that oversight had been discovered, they waited until a test case on the scheme had proceeded through the courts before assessing. The taxpayers argued in that case that the revenues discovery had become stale through the passage of time, and they said they were protected as well by section 29.5, and the upper tribunal eventually agreed with the 29.5 argument and dismissed the revenues appeal. Now, just if I may please go to PDF page 1314. At paragraph 17, the tribunal sets out the competing approaches to what a discovery is, and the revenue's position in that case at the end of that paragraph is that a discovery can be said to be made whenever an officer of HMRC realises that insufficient tax has been assessed. And so that's another way of putting Lord Briggs's, the answer to Lord Briggs's question, simply whenever there's a realisation. Paragraphs 24 through to 36, the upper tribunal comments on the low threshold required for there to have been a discovery, and your lordships will have already seen those passages quoted in Anderson. Moving on then, if I may please, to page 1318. Paragraph 37, which is the relevant paragraph relied upon by the Court of Appeal, is at the bottom of page 1318. Now, as we've set out in our written case, we have no difficulty with the first three sentences when the phrase newly appeared is interpreted as we say Viscount Simons intended it in Senlin. And we disagree with the next two sentences, and we say that that does not arise as a consequence of Senlin for the reasons I've already given. Now, in the event here, the upper tribunal observes that the delay in this case was to accommodate the final determination of another appeal on liability. And so the upper tribunal finds that on any view, that would preserve the newness of the conclusion. If I may please go to page 1319, paragraphs 40 to 42, so just further down that page under the heading Corporate Knowledge. And please could I invite your lordships just to read paragraphs 40 through to 42. So these paragraphs, and actually the upper tribunal in Tooth touched on the same idea, this idea of corporate knowledge. Is it sufficient for the assessing officer to reach a conclusion that's new to him, or must it be a conclusion that's new to HMRC as a whole? And now I say that it's clear from this discussion in Charlton that this question only arises because the upper tribunal in this case had first assumed or accepted that there is a concept of staleness. Now, if there is such a concept, then the point that the upper tribunal is making here is that HMRC can't escape the consequences of a stale conclusion simply by handing the file over to a different officer. But if, on the other hand, HMRC's position is right in this case, and staleness is not a concept, it's not a thing, then the words of section 29.1 can be given what we say is their ordinary and natural meaning. If an officer discovers an insufficiency, then the officer may assess, we say is simply concerned with a conclusion drawn by the assessing officer and no one else. So absent the concept of staleness, there's simply no need to open up an investigation into whether anyone else at HMRC had reached the same conclusion at an earlier stage, and if so, when. And that must obviously be right. Take the example of one officer who discovers something on day one and then issues an assessment 2 years later. You can't reach a different outcome between that case and a case where one officer discovers something on day one, files handed over at the end of the first year, and the second officer issues an assessment 1 year after that. Simply passing the file from one officer to another shouldn't alter the outcome, but in circumstances where there is no concept of staleness, then it doesn't matter who in HMRC, if anyone, may have reached the same conclusion at an earlier point. Now, this makes sense in practice because a taxpayer may well have his return scrutinised by a succession of different officers, or even by several officers at the same time. And we say it therefore makes no sense at all to interpret discover so as to give rise to the in-depth and complex inquiries into the revenue's broader investigations and decision-making to which staleness necessarily gives rise. So we say that it's important to understand that when Charlton and Tooth refer to this corporate knowledge concept, it's clear that this is as an adjunct to the concept of staleness. It's not its own freestanding principle. To put it another way, it's parasitic on there being a doctrine of staleness, and it doesn't have an independent life of its own. It's only relevant to ask who within HMRC knew what and knew when, if and only if you are having to analyse whether action was taken thereafter within some supposedly reasonable yet unspoken timeframe. And we say that staleness requires you to read in qualifications to the words of the statute in order to accommodate the consequences of the principle existing. But Section 29 is supposed to be simple. The requirement for an officer to discover is not supposed to open up some complex historical analysis of what has gone before. And reflecting back on what we saw in Jerome Anderson and the cases referred to therein, bearing in mind that the word discover is supposed to postulate a test of the assessing officer's state of mind, which is in part necessarily subjective, it makes no sense then to expand the inquiry to other officers who aren't the assessing officer. And so just to...
I have a question for you.
I'm sorry, my lord.
Yes, thank you, Ms. McCarthy. So just so I've got clear your submission, am I right in thinking that if we have an officer on day one who reads the relevant information and takes the view that there is an insufficiency of tax but does nothing about it, 6 months later, the file is passed on to Officer 2, who does exactly the same. 6 months later, it's passed to Officer 3, who does exactly the same. You're saying all this until the time limit, the long stop time limit, I think you've explained it, until that expires, Officer 6, let's say, who's done exactly the same, is then and makes the assessment, is at that point making the discovery, and that's all fine. Is that correct?
So taking it in stages, we would say that when you look at the plain and natural, when you take the plain and natural meaning of the words at section 29.1, the focus is wholly on the officer making the assessment. So my lord, in your example, you would ask the question, well, has that officer, so Officer 6 to take your example, has that officer made a discovery for himself? Now, you then moved on to say that's all fine. For the purposes of the wording of the statute and for the purposes of a statutory appeal, provided that that officer's assessment takes place within the statutory time limits provided, then we would say, yes, that is all fine. But we would not say, and this comes up in relation to my submissions on Patullo, we would not say that therefore HMRC can create administrative delay, can frustrate legitimate expectations, can behave badly in general. But what we say is, in that sort of a scenario, the actual problem is not with the satisfaction of the words of the statute, because a discovery was made. You don't lose the fact of a discovery with a passage of time. A discovery was made. The complaint is with the exercise of that officer's discretion to assess. Because if you recall, section 29.1 is phrased in terms of, if the condition is satisfied, the officer may assess. Now, in a case...
What I'm putting to you is, you really aren't accepting, as I understand it, any notion of what you might call corporate knowledge. On the example I'm giving, Officer 1 has discovered He's just done
Yes.
nothing about it. So through to Officer 6. And you're saying it's only Officer 6's own, because he's the one who's making the assessment, it's only that officer's knowledge and discovery that count. So there's no real concept of, on your analysis, corporate knowledge.
Exactly. If there is no concept of staleness, then there is no concept of corporate knowledge. Because the concept of staleness is all concerned with the passage of time between HMRC as a whole first appreciating something and the eventual assessing officer raising an assessment. And the corporate knowledge concept is an adjunct to that. And it says, well, if there is a concept of staleness, then you can't defeat it by simply one officer thinking, oh, I've sat on this file for 3 years. If I assess it's going to be stale, I know I'm going to pass it with a note to the person sitting on the next desk, and I'm going to say he should assess. If there is a concept of staleness, then corporate knowledge is part of that overarching principle. It's not a freestanding principle of its own.
Thank you.
I think
I'm thinking aloud, but I wonder if the concept of discovery might perhaps be argued to have inherent in it the idea that you're finding out something which wasn't previously known. I mean, if Marie Curie discovered radioactivity, or Fleming discovered penicillin, one wouldn't say that if somebody else had previously discovered the same thing, would one?
Well, the way that the language of the statute is phrased, it doesn't simply say if an insufficiency is discovered. It says if an officer discovers. And so the plain and natural meaning of that phrase, if an officer discovers, he may assess. So the focus is on, has the assessing officer discovered something? Has the assessing officer realized something for himself, we would say. Now, if there is a principle of staleness, then one is having to look back in time. One is having to say, well, when did the assessing officer first realize that? Or indeed, when did someone else realize that? But on each of these cases, in each case, the assessing officer has made a discovery for himself. The complaint, properly understood, is that HMRC as a body haven't acted sufficiently promptly thereafter. So what you would say,
I think the point that Lord Burrows is putting to you is really quite distinct from a concept of staleness. And I think the point being put is that discovery in itself means finding something out which the person working at the next desk hadn't already found out independently. I mean, if you like, you could have an argument about whether, I don't know, whether America was discovered by Columbus or Vespucci or some other Renaissance navigator. But you can't have that argument if the answer is they all discovered.
So, my lord, if I could just show your lordship the provision in the Commissioners of Revenue and Customs Act 2005. This is in the supplementary bundle, and it's page 8 of the supplementary bundle, please. That says anything, including anything in relation to legal proceedings begun by or in relation to one officer of Revenue and Customs may be continued by or in relation to another. So what that envisages here is the circumstance where someone begins something. So take this case, an officer back in 2009 began an investigation in a loose sense into Mr. Tooth's tax returns. His file has been passed on, as is only to be expected in a large organisation such as the Revenues, down the chain through the hands of various different officers. What we would say is that if it is the case that what you're interested in is the first time HMRC found out, then section 2.4 means that simply passing the file from one person to another doesn't in any way break any sort of chain, so that the officer at the end of the chain can't assess. Because there's a continuum throughout the investigation, and one officer simply picks up from where the other officer left off. So if there's a concept of staleness, then it may be the case, assuming a concept of staleness, that the 4 years in between means that the officer at the end of the chain can't do anything about it. But nevertheless, on that alternative approach, there was still a relevant discovery. There was a realization by HMRC of an insufficiency. If there is no concept of staleness, then there can be a realization at the start and an assessment later. A third way, so a sort of second fallback, if you like, a third way of looking at the provision talks in terms of if an officer or the board discover. So one might say that the discovery is made by Officer 1, or made by the board acting through Officer 1 on day 1, and the assessment is made by the board acting through Officer 6 on year 4, whatever the case may be. But the point is, all of those interpretations turn on whether or not there is a concept of staleness, whether or not there's a rule inherent in the legislation that the revenue must act promptly. Because in each of these cases, the complaint is not, well, HMRC never in fact realised at all. It's HMRC did realise. So whichever way you analyse my learned friend's case, HMRC did come to a realisation on his analysis. It's in 2009. The complaint is not that no one discovered anything at all. The complaint is that HMRC delayed in taking action. And so we say there was a discovery. There's always, whichever way you look at it, there's always been a discovery. Now, on our primary reading of the statute, we say the focus of the legislation is on the assessing officer and the assessing officer alone. He made a discovery. He made his own discovery when he picked up the file and he reviewed the file. And he was the one that took the decision to act. But if you don't accept that way of looking at it, then we say that section 2.4 of the CRCA 2005 deals with the example of where you've got a continuum of officers. Or the third way of looking at it could be to say that each time it was the board acting through one of its officers. But none of these different interpretations matter unless there is a concept of staleness. If there is a concept of staleness, and only if there's such a concept, then one becomes interested in the time frame between the, if I can call it, the first realization and action and assessment. And properly understood, that actually is a challenge to the assessing officer's discretion. The assessing officer doesn't have to assess, he may assess. If it's a challenge to his discretion, well, in all the circumstances, he shouldn't have assessed because of the administrative failures of HMRC, then that's classic judicial review. That isn't something that can be tested on the statutory appeal because the officer did discover. My Lord, I'm conscious that we're coming up to 11. Oh, yes, my Lord, Lord Briggs, I see you have a question.
I wonder if I can just dump the 5-minute gun by asking you one more question about Lord Borough's example.
Yes, of course.
Suppose that in his example, it was Officer 1 who made what you call the discovery, but let's call who appreciated that the self-assessment return understated the tax that was due. I think you say that is a perfectly legitimate discovery. If so, he appears to have an option either to open an inquiry or to sit around for 3 years and then go for a discovery assessment, bearing in mind that the minimum limitation period for a discovery assessment is 4 years, depending upon which of the conditions is satisfied. That, on the face of it, appears, or it might be said against you, appears to rather detract from what I suspect most taxpayers think is the benefit to them of a 1-year time limit for inquiry. If instead of doing an inquiry, the revenue can just say, well, we'll do a discovery assessment instead. And just before I finish, if you look at the conditions in section, I think it's 29, both the conditions seem to assume that either some misconduct of the taxpayer, negligence or worse, has led to an inquiry not being possible because the revenue has been misled by the return, or some other circumstances where it's reasonable for the revenue not to have discovered the point until the time for inquiry had passed. I'm finding it difficult to fit. Just the whole concept of discovery assessment depends upon one of those two conditions being satisfied, with the notion that actually the first human being within the revenue who reads a return can just say, well, I'm going to do this by discovery assessment.
And my lord, perhaps after the short adjournment,
Yeah.
or after the break, I'll show you the case of Tim Norton. The first tier tribunal has decided that exactly that would be entirely appropriate. What the revenue loses if it takes that course of action is it must then prove that either one of the two conditions has been satisfied, but there's nothing wrong at all for the revenue, even during the inquiry window, as the revenue did in that case, simply issuing a discovery assessment. And just before I finish, my lord, your example, if I may say, presupposes that the second condition about sufficient disclosure is sufficient to embrace a circumstance where there's been careless or deliberate conduct. But it's important to recognise that it's not. So if there has been careless or deliberate conduct, that is an entirely freestanding condition that the revenue can satisfy, irrespective of whether or not full disclosure has been made in the return. So the taxpayer protects himself essentially by not acting carelessly or by not entering into deliberate conduct. And if in that scenario that taxpayer has made full disclosure, then it's not that the case that the revenue can't assess because they haven't made a discovery. The officer will still have made a discovery, but he can't assess because neither of the conditions are satisfied, and that's where the protections come in. And so I may go after the short break briefly to Tim Norton, just to show your lordship what the first tier said in that case.
Thank you.
Very well. It seems we've reached a convenient moment, so we'll adjourn and resume in about 5 minutes' time. I think we're ready to resume now. Ms. McCarthy.
Thank you, my lord. So just before the short adjournment, I mentioned the case of Tim Norton, where the first tier tribunal decided that it would be perfectly permissible for an officer of HMRC to issue a discovery assessment during the inquiry window. They may not want to do that because they would, when they came to the tribunal, have to satisfy the conditions, but there's nothing to prevent the revenue from issuing a discovery assessment if the relevant discovery was made at an earlier time. And so just for your lordship's note, the relevant pages are PDF 1920 and PDF 1921. And it's paragraphs 137 and 138.
Could I just
Yes, my
ask,
lord.
on the facts of that case, was that a discovery assessment being made by the first human being rather than computer within the revenue who read the self-assessment return? Well, you may not know the answer, but if I could be told.
Well, I was about to say I don't think I know the answer because
No.
I don't think that there's any finding as to whether or not someone happened to have picked up the file before the assessing officer. what I would say is, even if there's a concept of staleness, in that scenario, there's no bar to a discovery assessment, because on any view, the initial realization, the first realization in the assessment would have been so close together. And that, I think, just to say the point again, is why I say that this corporate knowledge point really is properly understood and adjunct to the concept of staleness. If there's a concept of staleness, then you can't get around it by passing the file down a line of officers. But if there is no concept of staleness, then the legislation accepts and deals with the fact that a realization might have been reached by one person and someone else may act on it. And that's paragraph 2.4, as I showed your lordship again before the short adjournment. I suppose, to put the point another way, what we would say in that case is the first officer in HMRC realized that would have amounted to a section 29.1 discovery had he assessed. But if the officer doesn't assess, then you've got to ask the question, well, was there a relevant section 29 discovery by the assessing officer? And necessarily we would say that threshold has been crossed if that individual came to the relevant conclusion for himself. The fact that someone else in HMRC may have come to the relevant conclusion beforehand, or may have realised an insufficiency beforehand, does not preclude there from being a section 29 discovery when you come to look at the assessing officer. And that works hand in hand with staleness. And the other point that I'd make is the two cases that talk about corporate knowledge, both at Charlton and Tooth, the upper tribunal in those cases, they only recognise corporate knowledge as being a byproduct of staleness. Neither of those upper tribunals recognise it as a freestanding concept. So neither of them say, regardless of the passage of time, the moment you hand the file over, that's it, you can't assess. And that would be impractical and unworkable, because what if, for example, the first officer that came to the realisation then leaves HMRC, finds a job elsewhere? It cannot be that in that situation, HMRC all of a sudden finds itself precluded from issuing a discovery because the original officers moved jobs. That cannot be the right conclusion. So moving on, if I may, then to Portillo, which is the second case where the concept of staleness is discussed further, and that begins at PDF page 1476, please. So Portillo is a case where HMRC's thinking about the correctness of the taxpayer's return developed over time. And it developed because a test case on the avoidance scheme that the taxpayer had entered into made its way through the courts before finally being determined in the Court of Appeal and the Supreme Court refusing permission. Just for your lordship's note, page 1491, paragraphs 44 and 45, the upper tribunal here rightly considers that coming to a realisation, depending on the facts, depending on the case, might be a process that may evolve over time, with a conclusion being reached at the end. So a good example would be, for instance, the question of a taxpayer's residence. There might not be a certain point at which a conclusion is reached. It might be a process that evolves with the officer thinking they're sure, getting some more information, becoming less sure, looking at the case law, reaching a stage of being more confident, and so on and so forth until the end of that process. Staleness is considered at paragraph 46 onwards. That's PDF page 1492. Now, the first tier tribunal, and this is set out essentially at paragraph I'm sorry, at paragraph 46 and 47, in essence, the first tier tribunal below said that a discovery only became stale once the statutory time limit had expired, and we certainly agree with that way of looking at the concept of staleness. Moving on, if I may, please, to PDF page 1493, paragraph 49, just between little c and little d in the margin. The upper tribunal disagrees with that understanding of staleness, and Mr. Gordon, who was acting for the taxpayer, puts the submission this way: the question is not whether or not the assessment was within the statutory time limit. The correct question was whether the assessment was made while the discovery which triggered the right to make it was still fresh, or, to put it another way, whether by the time that assessment was made, the discovery had gone stale. Now, just pausing there, we say that that sentence in itself, that shows why we say there's no principal basis for reading in a concept of staleness, because it's clear there that staleness presupposes that there has been a discovery. What's being said is it's somehow lost its freshness, it's somehow lost its relevance. And properly understood, the effect, that the substantive effect of a principle of staleness is nothing to do with has there been a discovery. Necessarily there must have been a discovery, because it's the very thing that the taxpayer is saying has gone off. Properly understood, it's all to do with the subsequent action and the time the revenue takes with its subsequent action of assessment. So moving on then to the upper tribunal's reasoning, and the critical paragraphs are paragraphs 52 and 53, which appear on page PDF page 1494. Here, the upper tribunal takes a different approach. It doesn't focus on the word discover, because we would say the tribunal rightly appreciates that once a discovery is made, it doesn't somehow lose its newness. It's still a discovery. 52 and 53, the upper tribunal's approach here is in fact to look at the word if, and to interpret if as meaning if and when. Now, pausing there, we would say that's the wrong approach. And one of the paragraphs in Murano, if I can jump back to that, sets it out very nicely. Paragraph 82 of Murano, if I could ask you please just to go to page 1859. 1859 sets out very clearly that the primary meaning of if is on condition that, or given or granted that. If and when is in fact only the fifth usage in the OED, but only when the word when is used. And so there, the first tier tribunal considers that the proper analysis of the word if is simply a simple conditional conjunction carrying its primary meaning. And we would agree with that. So just returning, if I may, to the paragraphs in Patillo 1494. We'd also say that the illustration given at paragraph 52 of if and when the sun comes out, we'll go to the beach, is itself inapt, because, putting it bluntly, the sun will set, but once a conclusion has been reached, it's wrong to say you can return back to the prior state before that conclusion was reached. At 53, so paragraph 53, Lord Glennie accepts that, assuming the concept of staleness exists, it doesn't require HMRC to assess immediately. So even there, if there is a concept of staleness, HMRC will not be put out from assessing simply because the original officer who first realises might, for example, leave HMRC's employment and someone else might pick up the file and assess at a later point. Doesn't require HMRC to assess immediately. Lord Glennie then puts forward this concept that the discovery may be kept fresh depending on the circumstances. And so in that case, waiting for a test case to proceed through the courts was determined to be sufficient circumstances in order to keep the conclusion fresh. Over to the page PDF 1495. Top of page PDF 1495. It would only be in the most exceptional of cases that inaction on the part of HMRC would result in the discovery losing its required newness by the time that an assessment was reached. Only in the most exceptional of cases. And we say that that qualification has been completely forgotten about certainly in this case. Certainly at no point has the upper tribunal or the Court of Appeal identified what factors they consider this to be one of those most exceptional of circumstances, most exceptional of cases. Now, the only justification for this principle of staleness is given at the end of paragraph 52, so just back on the previous page, just by little g. Well, Lord Glennie says it would, to my mind, be absurd to contemplate that having made a discovery of the sort specified in 29.1, HMRC could in effect just sit on it and do nothing for a number of years before making an assessment just before the end of the limitation period specified in 34.1. And so that seems to be the justification for reading in this temporal aspect as something that the first tier tribunal can judge on a statutory appeal. But we say that that's a clear misdirection, and I make this point again, returning to the words of section 29.1, if an officer discovers an insufficiency, the officer may make an assessment. So properly understood, we say that the taxpayer's real complaint is with the officer exercising his discretion to assess, indicated by the word may. That's actually the true complaint that's going on here. What the taxpayer is actually saying is, well, in all the circumstances, we know the statutory test is satisfied, but actually you, HMRC, should not have exercised your discretion because of some other factor that means that it's irrational or illegal or would be conspicuously unfair to me, the taxpayer, for you to behave in this way. And you can imagine a situation, I'm taking an extreme example deliberately by way of illustration. You know, you can imagine a situation where on day one, there's dialogue between HMRC and the tax authorities. The taxpayer is told that the position is agreed. And then 19 years later, just before the end of the 20-year time limit, someone at HMRC pops up to say, aha, well, actually, strictly, we're still in time to assess. You know, in that situation, though, yes, it would be wrong for HMRC to raise an assessment, but the complaint is that the assessing officer shouldn't have done what he did. He shouldn't have assessed his discretion in that way. And that, we say, is a paradigm example of a judicial review claim. We identify that at paragraph 52 of our statement of case. So what I say is, Lord Glennie is not right to say, well, we must interpret the word if in this way, because otherwise the revenue could behave irrationally, precisely because the proper way of curing irrationality is by way of judicial review. And we refer to two cases in our written case, which are both very well known, Aspin and Estill and Corbett Numismatists. If I may just go very quickly to Aspin.
Just before we do, it may be of interest if we go back for a moment to paragraph 47 on page 1492. One can see how Lord Glennie starts this train of thought, and I think there may be a confusion between two different ideas here. He cites the passage from the Corbett-Starsham judgment, where the Special Commissioner says there's an aspect of a word discover, which I should refer. Discovery is something newly arising, not something stale or old. Something which newly arises from fresh facts or a new view of the law or otherwise. So that's talking about the nature of what a discovery is, that it's finding out something which is new in that sense. And then Lord Glennie says, on this basis, there's a temporal element to section 29. Once a discovery is made, HMRC must act with reasonable diligence. Otherwise, the discovery becomes stale. So I think he seems to be misunderstanding what the Special Commissioner meant. You know, he was talking about the concept of discovery. Lord Glennie treats it as imposing a requirement that once a discovery has been made, the assessment must be issued promptly.
Yes, my lord, that's absolutely right, and that's why we say, one of the reasons why we say it's wrong to read a temporal aspect into the word if, because necessarily it presupposes that there has been a discovery. It's just that action isn't taken soon enough. But we would say, my lord, that exactly the same feature appears if you try to read in this temporal element to the word discover, because necessarily there will have been a discovery. These cases are not saying there was no discovery at all. These cases are saying, so to take this case as an example, there was a relevant discovery in 2009. If UHMRC had acted in 2010, there'd be no problem with that. Come 2014, all of a sudden it's too late. And necessarily then, the existence of the discovery in 2009 is being fully recognised. What's being said is, but the discovery has somehow gone away again because in fact you didn't act by 2010, hypothetically, you waited until 2014. So whilst it's true that putting the emphasis on the word if is a more obvious example of what we say is the flaw in the judicial reasoning, actually the same flaw arises precisely because it is accepted in both examples. There was a point where the threshold is crossed, but somehow the passage of time has denatured the discovery so that it's no longer a section 29 discovery. And we say that that's the wrong way of looking at it, because the effect of that, the function of that, is not to say, well, actually, there was never a discovery at all, because looked at through the lens of someone standing at 2010, there absolutely was a discovery. The problem is that you didn't take subsequent action in time. And that's nothing to do with if and nothing to do with the word discover, we would say.
I don't know if you're going to deal with this at some point, but obviously it's said against you that far from there having been a discovery in 2009, we have no finding in fact to that effect, and that case was being disclaimed by the Revenue until this hearing. Yeah.
And I will deal with the pleading points, because we say that actually that's not apt, and that's not correct in terms. Well, we say three things. First of all, that's not accurate. Secondly, on any view, there are findings in the first tier, the upper tribunal and the Court of Appeal, as to why it is we lost. And thirdly, we're not, how can I put this? We're not at the last moment springing up and running a positive case about the existence of a discovery in 2009. All that we are doing is living with the Court of Appeal's findings, and the Court of Appeal is entitled to draw conclusions on the facts. And we are saying, well, that is what the Court of Appeal has concluded. The Court of Appeal has concluded there was a realisation, if I can call it that, in 2009. Nobody at any stage has said that Mr. Williams in 2014 did not have the correct state of mind. And so as night follows day, the requirements of 29.1 necessarily have been satisfied on that analysis. So I was just about to turn briefly to the relevant passage in Aspin, so that your lordships have seen it. It's page 1161 in the PDF. That's the first page of the decision. And the complaint here, the taxpayer's complaint here, was that the Revenue had told him over the telephone that tax wasn't due on certain income. He had relied on that assurance to his detriment, and so it would be unfair for the Revenue now to assess him. And the Court of Appeal firmly rejected the idea that that could be the subject of a statutory appeal. The relevant passage is on page 1165 in Lord Justice Nichols' decision between little c and little d. The taxpayer is saying that an assessment ought not to have been made, but in saying that, he's not under this head of complaints saying that in this case there do not exist in relation to him all the facts which are prescribed by the legislation as facts which would give rise to liability to pay tax. What he is saying is that because of some further facts, it would be oppressive to enforce that liability. In my view, that's a matter in respect of which, if the facts are as alleged by the taxpayer, the remedy provided is by way of judicial review. Now, here, the first-tier tribunal's jurisdiction is set out under section 50 of the TMA, and that's PDF page 874. And it's section 50, subsection 6. If on an appeal notified to the tribunal decides that the appellant is overcharged by an assessment other than self-assessment, the amount shall be reduced accordingly. So the relevant word here is overcharged. And just for your lordship's note, at paragraph 53 of our written case, we've set out examples where the tribunal has determined that overcharged in section 50 sub 6, or the word incorrect in the case of penalties, should be interpreted as meaning according to the proper operation of the Taxes Acts, and not because there's an overcharge or an incorrect penalty by virtue of being disproportionate or somehow being unfair. And we've included a further case on looking at the language of what the statutory tribunal can and can't do. It's Boscher, the case of Boscher, the Upper Tribunal's decision at 1332, PDF 1332. That was a case concerning penalties. And the taxpayer's argument was that in the relevant circumstances of the case, the penalties were disproportionately large and it would be unfair for the tribunal to confirm the assessment. And in that case, it was penalties of 54,000 for late filing, which significantly exceeded the amount of tax that was actually due under the returns, many of which were in fact nil returns. So the relevant paragraphs that I'd like to go to, please, are paragraph 17 at 1339, page 1339, paragraph 17. And in paragraph 17, the Upper Tribunal is talking about the statutory tribunal's jurisdiction. And over the page, just by little b, in particular, neither that provision, so that's the provision to correct incorrect penalties, nor any other, gives the tribunal the discretion to adjust a penalty of the kind imposed in hoc, or in this case, because of a perception that it's unfair or for any similar reason. And then the only other relevant part of Boscher is on page 1348, 1348. Paragraph 54 at the end of the page. We have no doubt the unambiguous meaning of the language used is that the word incorrect means not the correct fixed, it means not of the correct fixed amount as prescribed by the legislation. It does not include penalties which are incorrect by virtue of being disproportionate and breach of the taxpayer's rights under Article 1 of the first, under Protocol 1, Article 1. So in other words, in that case, there was no scope on a statutory appeal for giving the word incorrect a more expansive reading, because the statute conferred on HMRC a decision to mitigate. If HMRC failed to exercise their discretion properly in relation to mitigation, that was a subject for judicial review. And we say, as I've already mentioned, the same rationale applies here, where the statute expressly accepts that an officer can assess at any time up to 20 years. There's no scope for interpreting either what the word discover or the word if in such a way as to confer in effect a judicial review jurisdiction on a statutory tribunal. Now, saying that staleness is somehow inherent in the word discover is a mischaracterization, and we say it's a sleight of hand, precisely because it presupposes that there has actually been a discovery sufficient to fall within the terms of section 29(1). So if so had action been taken, as I've already said, in 2010, there'd be no doubt that there'd been a discovery. But the true complaint is that the discovery has somehow ceased to be. And saying that staleness is inherent in the word if is likewise wrong, we would say, for exactly the same reason. It presupposes that there's been a discovery which ceased to exist due to the passage of time, as illustrated by the way that Lord Glennie put the point in Patillo, the paragraph that my Lord Reid referred to earlier. Put it another way, functionally, the effect of either interpretation is to create a freestanding time limit, but that is expressly contradicted, we say, by the clear words of the statute. And properly understood, staleness is not a challenge to a statutory precondition, therefore. It's actually a challenge to the officer's decision to exercise his discretion. It's a challenge to may. It's a challenge to what the officer did in relation to the word may. But that is classic judicial review, because the word overcharged in section 50 sub 6 can't be interpreted to accommodate perceptions of unfairness. One last point is to say that there might be all sorts of reasons why a taxpayer may wish to challenge an officer's decision to assess. So, for example, you can imagine that HMRC might have given clearance for a transaction to go ahead. The taxpayer might have relied on that clearance to their detriment, and in circumstances where there's no delay, so there's no possible staleness argument at all. Rather, the challenge there is pure legitimate expectation and unfairness. And you can't solve that by reading in some wording in a no delay case into the words of section 29(1). That's a case where the remedy would be judicial review, if that was a legitimate complaint that the taxpayers could make out. This case here is no different at all. So just to draw the threads together, we say that the Supreme Court should reject the notion of staleness for the following 7 reasons. It goes against the clear express limitation provisions. In the circumstances, the court should not, therefore, read in some time limit to the word discover or if. Discover simply means find out, no more, no less than that. If is simply conditional, no more or less than that. It was entirely open to Parliament to impose a requirement that HMRC acted promptly, and we've seen the sort of requirement that looks like in the VAT legislation, yet the Parliament clearly did not do so. Moreover, discovery is supposed to be a low, workable, practical hurdle. All that is required, as we've seen clearly from the cases, is for the assessing officer to come to a genuine and reasonable conclusion that there's an insufficiency. And that's clear from McKinley's trustees, Senlon, Jerome Anderson, and all the other case law that Jerome Anderson refers to. It sets, in other words, a minimum threshold as to the state of that officer's belief. That's the purpose. So discovery does have a purpose. It's setting a minimum threshold as to the state of the officer's belief, protecting taxpayers against mere speculation and nothing more than that. And remembering that if an officer speculates that a return is wrong, well, they have 12 months in which to open an inquiry for any reason, any speculative reason whatsoever. We say, this is our 5th reason, the cases have taken a wrong turn and created a wholly new requirement out of a gloss that Lord Simons placed in Senlon, but the context in Senlon was totally different to how that gloss is being used in the cases now. The only justification found in any of the cases for reading in some reasonable period requirement is that it can't be right for HMRC to sit on its hands and do nothing. But administrative delay is a classic example of grounds for judicial review. The real complaint is against the officer's discretion, classic judicial review. We say the concept of staleness has created significant uncertainty and impracticality. Numerous tribunal decisions have rejected the concept, we say rightly. And in paragraph 61 of our written case, we've identified 5 such examples, but they are by no means the only ones. Those are my submissions on the law in relation to staleness. I now intended to turn to the facts. So, assuming that your lordships accept my submission that there's no concept of staleness, and all that's required is for the assessing officer to come to a genuine and reasonable conclusion that there's an insufficiency, it follows from that that the first tier's decision is entirely right for the reasons it gave, and the Court of Appeal's decision is wrong in law on its own terms. And that doesn't require us changing our factual case and making some new pleading at this late stage. So I'd like to turn, if I may, please, briefly to the decisions below and also address what my learned friend says about the pleadings. If I may start off, please, by the first tier's decision. And please could I ask your lordship to turn to page, PDF page 219. The first tier's discovery on the first tier's decision on discovery is set out briefly at paragraphs 43 through to 46. The appellant's case, so Mr. Tooth's case on discovery, is set out at 44, and we say it's clear from this that the appellant's case below was confined to newness. There was never any question that the assessing officer, Mr. Williams, did not himself hold a genuine and reasonable belief that there was an insufficiency. Mr. Ghosh contends that the facts of an insufficiency cannot have newly appeared to an officer in 2014 and cannot therefore have been a discovery. So the case is confined purely to newness. Pausing there, that's consistent, we say, with Mr. Tooth's grounds of appeal at paragraphs 12 and 14. And just for your note, these are PDF pages 364 and 365. It's clear from those grounds that the complaint is against newness. So we say once the test is properly understood, then the first tier was entirely right at paragraph 45. There's a low threshold for a discovery, given the low threshold necessary for there to be a discovery. I prefer Mr. Villat's argument, that was counsel for HMRC before the first tier in the upper tribunal, that it's necessary to consider the position of the assessing officer, in this case Mr. Williams, and whether he made a discovery, which does not depend on something new being discovered by reference to HMRC's collective knowledge. So here the first tier has rejected the collective knowledge argument because that's simply an adjunct to staleness. As such, I find that Mr. Williams did make a discovery of an insufficiency of tax in October 2014, as confirmed by the emails of 23rd October 2014. And October 2014 is the relevant date as regards Mr. Williams, because that is when he first reviewed the file. So assuming no concept of staleness, assuming therefore there's no concept of collective knowledge, that's entirely right because Mr. Williams reviewed the file for the first time then.
The way Mr. Ghosh is recorded as putting his argument, the collective knowledge issue was quite distinct from any question of staleness. If you look at paragraph 44, Mr. Ghosh contends that the fact of the insufficiency, as this was first identified in 2009, Mr. Ghosh contends that the fact of the insufficiency cannot have newly appeared to an officer in October 2014 and cannot therefore have been a discovery within section 29.1. So that's the first point. It's not new, therefore there's no discovery. And then the second point is, in any event, by October 2014, the discovery was stale. Aren't those two separate?
So this is just returning to what I say about the concept of collective knowledge properly understood. We've already seen in Charlton, and the section in Tooth Upper Tribunal deals with this in the same way. Collective knowledge is merely an adjunct to staleness. It's not its own freestanding idea.
Okay, you keep saying that, so I've got your position.
But on any view, what we would say is, if there's a separate point being taken that merely someone else in HMRC first realised, we then would rely on, as I've already said, section 2.4 of the CRCA, which makes it clear that one officer, anything begun by one officer, can be carried on by another. So we would say anything here, the relevant anything here is the review, the investigation into Mr. Tooth's return. So anything begun by one officer can be carried on by someone else. And we say that eliminates any problem of files being passed from one individual to another, unless there's a concept of staleness, which then is, if you like, in that scenario, its own separate complaint. So collective knowledge in and of itself, if the only complaint is collective knowledge, we say that's a non-complaint by virtue of section 2.4. But on any view in the case law, collective knowledge only actually gains any momentum because of the concept of staleness. So you can't simply pass a file off in order to defeat the concept. But if there's no concept, there's nothing to defeat. And as I already mentioned in my opening, we're not proposing this as the correct way of approaching section 29. But another way would be to say, well, actually, in both cases, the board acting through one of its officers made the discovery, and the board acting through another of its officers made the assessment. But there's no basis for implying anything, any bar into HMRC raising an assessment simply because the file was passed from one person to another. What we would say is paragraph 45 illustrates that the first tier tribunal has understood and has accepted HMRC's primary case, but the focus is solely on the assessing officer. If that is right in law, then there's a clear finding that Mr. Williams had the relevant state of mind in October 2014 when he first looked at the file, and that has never been challenged on appeal. Now, it's correct that the assessing officer did not give evidence at the hearing, since by then he'd retired. Mr. March, his predecessor, was one of 3 witnesses for HMRC. And I think if we may just briefly turn up his witness statement, because we'll see that at page 661 of the PDF, please. He sets out at paragraph 2 of his witness statement the chronology in 2014. He was one of the technical leads for HMRC's response into the tax avoidance scheme known as Romangate. He took over from Mr. Nigel Clark in April 2014 and was succeeded by Mr. Williams in August 2014. Mr. Williams was the technical lead at the time the assessments under appeal here were made, but he is retired. At paragraph 8, so this is just skipping forward to PDF page 663, paragraph 8, Mr. March has given evidence as to what Mr. Williams did in October 2014. He reviewed Mr. Tooth's file and concluded in line with mine and Mr. Clark's thinking before him that he had discovered a loss of tax as a result of the appellant deliberately filling out his tax return in the manner he did. Mr. Williams therefore wrote to the operational team responsible for administration of sending out assessments with that recommendation. So there's there's evidence here from Mr. March as to what Mr. Williams' thinking was, the fact that it was in line with him and his predecessor, and this is all concerned with April 2014.
Can I?
Sorry, the point from April 2014 onwards.
I'm sorry to interrupt you, but can I ask you, why are we looking at a witness statement? We're not a fact-finding body. The facts have to be found by the FTT.
So the purpose for showing you this is my learned friend has made a complaint about the fact that there wasn't a relevant witness to cross-examine and at our pleadings. So I'm simply showing your lordship what the relevant evidence was. Mr. March was cross-examined by counsel, but if, my lord, I could ask you please to go to PDF 215, and it's the bottom, the last two sentences in paragraph 32 of that page. You can see the finding of fact then that emanates from that witness evidence in the first tier tribunal's decision as to Mr. March's actions in 2014. And clearly the fact that he had come to the conclusion that the discovery assessment should be issued. Now, it's also the case that Mr. Williams' name did not appear at the bottom of the letter sent to the appellant, but that doesn't affect matters, and we'll see that what the first tier says about that at paragraph 33 of its decision, the very next paragraph, the first sentence, first couple of sentences. And again, we say that the passing on of the file in this way is clearly, again, another situation that's covered by section 2.4 CRCA, as we've already seen. Now, my learned friend's complaint is that HMRC failed to plead or prove a clear case as to when who in HMRC first realised the return was insufficient and when they reached this view. But if we are right, absent a concept of staleness, we say these matters are legally irrelevant because the focus is simply on the assessing officer. But on any view, it's clear from Mr. March's evidence that I've just shown your lordship that he and his predecessor were of the same view. So counsel for Mr. Tooth, we would say, had ample opportunity to ask the witness who was there at the time anything he wanted to about when it was that HMRC collectively first took a view and whether in fact HMRC had known all along since 2009. After all, Mr. March would have had access to the file, and we would say it's not open it's not open to Mr. Tooth's counsel. It's not open to my learned friend to fail to request further and better particulars, to fail to put relevant questions to a witness who was actually there at the time, and then complain that the first tier does not have a clear chronology set out. In any event, the precise circumstances that led HMRC to first realise there was an insufficiency are clearly articulated in HMRC's skeleton before the upper tribunal. This is page 318. Page 318, it's little g on that page, read together with the footnote. In December 2013, the scheme promoters conceded that the scheme did not work. HMRC then reviewed all claims utilising the scheme. When Mr. Tooth's claim was reviewed, HMRC realised, footnote, following an exchange of correspondence with the appellant's agent, in light of Cotter, decided in November 2013 that the claim had been made within Mr. Tooth's 2007-08 return. Now, just pausing there, that paragraph in the upper tribunal skeleton identifies clearly the first realisation was in light of what we have referred to as the Grunberg correspondence. It identifies clearly that HMRC first realised that the claim had been made within Mr. Tooth's 2007-08 return. And as I have set out, the insufficiency here arises precisely because it should have been treated as a claim made in the return. If the claim is made outside the return, the self-assessment isn't reduced. If the claim is made in the return, the self-assessment is reduced. And it's only following the exchange of correspondence that HMRC first appreciated that on the particular facts of this case, this was an example of Lord Hodge's commentary in paragraphs 27 of Cotter, that there was a way of forcing a claim into a return. Now, the important point about showing your lordship this paragraph is when we go on to look at Mr. Tooth's skeleton argument before the upper tribunal, the one thing that Mr. Tooth does not do is say, well, hang on a minute, you can't possibly say what's at paragraph 4G, you never said that before. Now, we don't have a transcript of what went on in the first tier tribunal hearing. We do know there was live evidence. We do know there was factual argument because the first tier made findings. When you look at Mr. Tooth's response in his upper tribunal skeleton argument, page 337 onwards, having set out the case law on discovery, so Charlton and Patillo, page 337 onwards, paragraph 29 onwards, the complaint here is as to newness. The complaint is that in October 2014, there wasn't a new conclusion. The complaint is all about staleness linked with corporate knowledge. But nowhere does the appellant say, well, hang on, you've never said this before. And so we would suggest that whatever was said in that first tier tribunal hearing, it must have aligned with what was then said in the upper tribunal skeleton, which wasn't objected to at the relevant time. If I may then please turn briefly to the upper tribunal's decision, that's PDF page 177. The upper tribunal's decision on discovery turns purely on staleness. That discussion starts at PDF page 196. In particular, corporate knowledge is dealt with at PDF 198. At paragraph 77.4 through to 77.7. And having accepted the concept of staleness, so having accepted the concept of staleness at paragraph 77.1 to 77.3, the upper tribunal then says it follows from this, so as an adjunct, as a consequence, it follows from this that the same officer or officers cannot make the same discovery twice.
I'm sorry, Mr. Carvey, are we in paragraph 79? I think you said 77.
I'm sorry, I think I must have had a wrong reference. Yes, 70, yes, 79, I think I meant 4 through
That's
to
all right.
7.
Thank you.
And so again, I reiterate the point, it's simply a consequence of staleness. Then turning to the upper tribunal's decision on the facts, paragraph 1, I'm sorry, PDF page 199, was there a discovery in the present case? At 82, the upper tribunal says the first tier appears to find that the discovery was first identified in HMRC's letter of 14th August. Well, pausing there, that wasn't actually what the first tier identified, but the first tier might have identified that HMRC first realised 14th of August 2009. Moving on to 83, no doubt the facts that triggered the letter could have amounted to a discovery. So there's no doubt that this realisation that the upper tribunal says HMRC collectively held was sufficient to amount to a discovery. However, that would mean that the discovery was in 2009, whereas the assessment was made some 5 years later. At 84, the first tier considered and rejected staleness. The upper tribunal acknowledges that the first tier's decision relies on the state of mind of Mr. Williams, but with their findings on staleness in mind, what is said by the upper tribunal at 85 is the exact findings of fact made by the FTT do not emerge clearly from the decision. If the FTT found that Mr. Williams simply discovered what another officer already knew, then for all the reasons we have given, we consider that that was no discovery by Mr. Williams at all. Those are all the reasons based on the concept of staleness and its adjunct corporate discovery. Accordingly, we conclude that no such finding.
You're again eliding what I thought were two distinct points. I mean, you complain that staleness, that staleness is seemingly a requirement to issue an assessment within a reasonable time of making the discovery, and there's no basis for that because there's nothing about that in the statute, whereas there is a statutory time bar. The second point is what actually amounts to a discovery in the first place, and that seems to be the point they're focusing on in paragraph 85, and they say there's no discovery by Mr. Williams because of the corporate knowledge that this was already known.
And my lord, my two answers to that are, first of all, on any view, corporate knowledge makes no difference to the outcome because of section 2.4 of the CRCA. So that's my answer, that it doesn't matter who did the finding out and who did the assessing because of section 2.4 CRCA. It can only start to matter if you accept that there's this concept of staleness, so that there's a delay then between who had the initial realization and who made the assessment. That's the only way in which both the cases treat it as mattering. And again, I appreciate, my lord, I've already made the submission, but take a very simple example where an officer has a realization and then the very next day leaves HMRC or leaves the month later. In that case, it would be right to say, I think, my lord, it would be right to say in that scenario that the new officer is simply finding out something that the officer that's now left has found out before, but it'd be completely wrong to say, well, in that situation, unfortunately, HMRC can't raise an assessment because the officer has left their employment. So they are two separate points.
Well, the answer to that may be that it's no longer, but if the officer who knew it leaves their employment and nothing else happens, then it's no longer within their corporate knowledge. We're dealing with a situation where the officer doesn't leave. The question then is there a discovery if one officer finds what his colleague sitting perhaps at the next desk already knows?
Well, bearing in mind that all the officers here work in teams, you can simply adjust the example to say, there's the officer that first comes to the realization, who discusses matters with their colleagues. He or she then leaves the revenue. His knowledge is plainly, or dies, to take another example. His knowledge has plainly been passed on to his colleagues. It remains within HMRC throughout. The only thing that has happened in that case is he or she is not the officer that makes the assessment. And it can't be right in that situation to say, well, all of a sudden, out of nowhere, the ability of HMRC to assess is lost. In that scenario, I think even the upper tribunal in Charlton and Tooth would accept that HMRC can still assess, assuming that the assessing officer has the relevant belief. Nobody would suggest that that can't possibly be a discovery because it's already been realised by HMRC. The only thing that these tribunals are saying makes a difference is because of the lapse of time between the initial realisation and the assessment. And that's, if you like, the mischief that these decisions are trying to cure. They're not trying to cure the mischief of a file simply having been passed on. They're trying to cure the mischief of a delay in time, of the passage of time. Yes, my lord.
Just to be clear, if we were with you on your staleness analysis, it makes no difference to you, does it, whether the discovery was in 2009 or 2014?
No, it doesn't. And that's exactly why we say that it's not a matter of pleadings. The Court of Appeal's judgment in that scenario is simply wrong on its own terms, because the first tier tribunal suggested that August 2009 might have been a time at which HMRC realised there was an underassessment, an insufficiency. Now, as a matter of detail, we say that can't be right in circumstances where Mr. Tooth in fact amended his return at the end of 2009, but that's just a detail. The upper tribunal, in the passages that I've just read out, form very clearly the view that they say on the law, discovery is the point of first realisation by anyone in HMRC. Well, if that is the right test, that happened in August 2009, and therefore the assessment is stale because of the passage of time. The Court of Appeal, as I'll go on to, essentially identifies that HMRC knew all along, the suggestion being HMRC realised from the very first moment a human looked at the return, August 2009, and the Court of Appeal agrees with the upper tribunal's analysis, but not with the upper tribunal's remedy. And so that's why we say that if we're right and there's no such concept of staleness, then on any view, there's no question that HMRC came to the realisation on the upper tribunal and the Court of Appeal's view in 2009 and acted in 2014. And the two things that have not been called into question are the very fact of a realisation of an insufficiency and Mr. Williams' own subjective knowledge and belief in October 2014. And if there is no concept of staleness, it doesn't matter to us when HMRC first realised, to use those words, because HMRC first realising is not the statutory test. If I may, just for your lordship's note, we say that our case has been consistent, in particular with what the case was before the upper tribunal, and to which my learned friend didn't object. Just to give your lordship page numbers in our page numbers to our skeleton argument, so your lordship can see this before the Court of Appeal. It's PDF page 258, paragraph 617. PDF page 265, paragraph 40, and PDF page 276, paragraphs 40 to 48. It's also relevant to look at how Mr. Tooth put his case before the Court of Appeal. And so if I may just ask your lordship to turn to PDF page 286. The paragraphs that are relevant are paragraphs 16 through to 21, and this is Mr. Tooth's skeleton before the Court of Appeal. But you'll see quite clearly at paragraphs 20 and 21 In summary, then, the revenue's factual case before the first tier was that, and only that, the relevant officer concluded that Mr. Tooth's return contained an insufficiency because of the incorrect inclusion of a partnership loss figure. The problem with that is it wasn't new. So if we are right about the correct law, and the correct law is focusing on the quality of the assessing officer's conclusion, then by the Court of Appeal, even my learned friend has agreed that that was the case that was put below. Turning then to the Court of Appeal's judgment, which begins at PDF 147, as we've identified in our written case, the error of law is at paragraph 60 and 61, which is at PDF 163. In particular, where at 61, the Court of Appeal agrees with the upper tribunal in Charlton, including the passage on, in effect, staleness. And then at paragraphs 53 and 55 of the Court of Appeal's decision, the Court of Appeal notes at paragraph 53, so this is page 161, bottom of 161, the first identification in HMRC's letter of the 14th of August, and at 55, in the quote at paragraph 55, page 162, the upper tribunal's finding on the law that HMRC discovered the insufficiency in 2009. PDF page, I'm sorry, I don't have the relevant page. It's paragraph 70 then, PDF page 165 of the Court of Appeal, is the finding that HMRC had always appreciated there was an insufficiency in Mr. Tooth's self-assessment tax return. And then a few lines below that, yet further until this appeal, it has been said consistently by HMRC that the discovery was made by Mr. Williams when he reviewed the file in October 2014. Now, that is correct in terms of the discovery that Section 29 focuses on, the discovery of the assessing officer. But on any view, we say that that underlines an error of law made by the Court of Appeal in failing to appreciate that that was the discovery that mattered. And if that is the discovery that mattered, the fact that HMRC might have realised earlier is legally irrelevant. And so we say once the concept of staleness has been rejected, then on the basis of the Court of Appeal's own findings, HMRC's case succeeds because there's no challenge to the first tier's conclusion as to the quality of Mr. Williams' own discovery and the quality of the belief he held in October 2014. The only challenge is that he wasn't the first person in HMRC to realise that. My Lord, might this be a convenient moment to break for the short adjournment?
Yeah, thank you very much, Ms. McCarthy. We'll adjourn now and resume at 2 o'clock.
Thank you.
Thank you.